Good morning. Today, because of some problem, we were not in position to discuss the issue or the topic which was fixed earlier to discuss it today. But anyhow, luckily, I got the internet connectivity. That's why it may be some late, but I'm trying my level best to take your classes continuously, to complete the course, and for your information, so that you may develop your habit according to the study of LLM. Please don't take it casually, just like the study of LLB. It is a LLM, totally different from the graduation course, and requires to read the good books. Good books means books where there is a commentary, analysis, criticism, and interpretation of the cases, and the right to special kinds of the note on the existing material. Thus, that today's topic, as partly we have discussed yesterday about the origin of the federalism. You have seen the War of Independence of America and the Constitution making process in United States of America, because the origin we have discussed about the system of American Constitution. Today I have given some component divisions and some integrants of the study, and under these integrants, the today's aspect is the meaning of the federalism. Basically, the meaning of the federalism has not been defined anywhere, but it is a boon of the habits and ideology interpretation of the court about the system of the polity in particular country, and that polity comes from the constitutional system and provisions of that country. In this reference, if we will see the basic meaning and concept of the federalism, we will reach in conclusion that where there is a distribution of powers in between the state and the center, and both have own autonomy in their distributive work. It may be the work of the legislature, and it may be the work of the executive affairs, and taxation also, financial matters. Therefore, the indication of the federalism is the distribution of every kind of the power in between the two units, which is in the center, which is called the federal union, or the center government, whatever the name it may be called according to the word given by the constitution makers by providing the provision for that under the Indian Constitution or any other constitution. The name can be given for that purpose to the what is the name will be called of that center and the union. Then come into the point which is very relevant and it will be easy for you to understand the system of federalism in India. I have said that the history begins from the Government of India Act, and at the time of this 1800, that was the 1857, there was the first independence struggle movement, and then gradually the 1918, the Government of India Act Charter, first of all, the one of the Montesquieu reform that was issued, but as a act, enacted act came into force, or called the 1919. And because of that Government of India Act of 1919, and there was the unit, political unit established in India, which was called the legislature, legislative assemblies, and another side there was the federal system and all these things. But very most relevant and powerful legislation which had issued by the British government is called the Government of India Act 1935. Government of India Act 1935. The seeds of the federalism is in the Government of India Act 1935. In short, it is called the GOI, Government of India Act, and abbreviation you should have the habit to write the abbreviation short words. And first, you can write in a first line when the reference comes. Please try to understand, when the reference comes of a detailed act or detailed legal word, you can write in detail. For example, Government of India Act 1935. But after that, when it will repeat means the same act will come again for writing. You can write the GOI Act, and when you will make the abbreviation GOI full form, you will write in the first of your assignment, your project work, your research work, and your research paper. Therefore, the habit should be developed to write in short of any name of the legal act or the words, and that is called GOI Act of 1935. And what it has made, and why it was made, and what was the reason of making that Government of India Act 1935, because I have pointed out that the federalism which is existing in our Constitution of India have the seeds origin from the 1935 Act. And you maybe remember, please, one thing, download the Government of India Act, and PDF should be in your laptop or in your mobile. And whenever it requires to enter into that portion of the constitutional system in India, it is very essential for you people to go through the Government of India Act 1935. And the base of the Indian Constitution, basically of the executive, parliament, and the legislature, is the Government of India Act 1935, GOI 1935. And therefore, the every aspect you must have to go through the Government of India Act 1935. And the question, when it had given the assent by the royal, and the royal assent, when it has given, how many sections are there, what are the provisions in that Government of India Act GOI 1935, and when it had repealed. So many questions are there, and how far the provisions with certain modification had adopted by our constituent assembly, constitution makers, to give the place in the Indian Constitution. How far, and what is the modification, what is the system, and as I have used the word royal assent, and royal assent was given to this GOI 24th July 1935. 24th July 1935. And it is very interesting. India became the independence on the 15th August 1947. But after that also, up to the 26th January 1935, or before that, also India government of that Independence Act passed in 1947, as I have highlighted yesterday. But the government of India GOI 1935 Act repealed on the 26th January 1950. It has repealed on the 26th 1950. Then another question: how many the sections, what are the provisions under these one? I have suggested download it, but I'm just quoting that there are under the GOI Act, there are schedule are also there, sections are there, article are not there. It is not called the article, it is called the section, because it is written in that form that its name shall be the section, because it is a act. It is not a complete document as such as the constitution is called. And I have pointed out earlier that why it is the basically of the article under the numerical numbers are the article under the Indian Constitution, because of this 366 article 366, which gives the definition of every word used in the Constitution. It is a basic special kind of the study. That's why continuously I am with full efforts taking your classes. It is LLM. I have said that it is LLM. Again and again I am repeating it. You may be the practitioner, but at the same time, the one may not have the capacity to analyze the things as per the master degree, have the capacity. And you are lucky enough that you are getting the classes continuously because of your interest and because of the teacher who is doing the best efforts in this lockdown period also. Then my point is relating to the deep study. That was my point, and that's why I have given the example. I'm repeating again and again, and you should have to serious about it, because I have seen the habit of the student when they are sending me the assignment number 1, and some have in the initial stage the whole material downloaded and send me, and they ask me to tell me the whether this is relevant. This is not the way, because one degree you have got it, and you should have the capacity. That's why I'm trying the best to give some basic idea about the analysis of law, about to develop the capacity to do the hard work and understanding it, not to take it very easily. Now, okay, that is because it is a online lecture, and that is not possible to do all information. If class face-to-face class will be there, then we will narrate all these things also. Then there are 321 section. Why it is section? I have just pointed out. Why the article is article, I have just given. And General Clauses Act, it may be in your knowledge, because if you are practicing in the High Court or some places, you may know the every aspect of the law, and continuous to sit in your chamber near about 8 hours and 7 hours to do the work, and continuously whenever the lockdown will over or end, then it is the full expected from you, or the 100% expectation of my to you to from you people to attend the class. But there are 321 sections. In GOI 1935, there are 321 sections, and the schedule are 10. And royal assent got that enacted law is 24th July and up to the 26th January 1950, and it had repealed after that. Therefore, whenever we are talking the federalism concept in India and the interpretation of federalism in India, we should have the idea of some basic provisions of GOI. We should 1935. Otherwise, we cannot complete it. We cannot assess it. We cannot be in position to interpret it, and we cannot be in position to apply in such a manner so that the principle laid down by the some jurist, as I have pointed out in the year of 1787 by Alexander Hamilton, John Jay, and James Madison. And after that, the book in 20th century, which has written by some other jurist, belongs to the Australian system of education, because they were the professor and they has written very good book on the federalism, the federal government and the modern federalism. And they were the person who has written Jeffrey Sewell and the Casey Ware. They have discussed all these things because of these principles, which has originated by some jurist, originated by some professor, academician. What shall be the federalism? How it will be called the federalism? Because of these principles, as I have discussed yesterday in first part and second part also, I have discussed this 1919 Act and some other illustrations relating to the federalism. Today, I am entering into that portion which is related to the 1935 GOI. And after going through the ideology expressed by these persons who taught the constitutional law in Australia, because you have seen the federal character of the constitution is existing basically in the USA, Australia, Canada. And in this way, there are two models. One model is related to this USA and Australia. This is one model. And another model is Canadian model, the Constitution of Canada. And Constitution of Canada model we have adopted in India, although the seat's origin is the Government of India Act 1935, but at the same time the model which it has adopted in India, that is existing in Canada. And the source of our federal character of the constitution is the model which is existing in the Canada. And the Canada was one act was passed in the Canada which is called the BNA Act. BNA Act of 1867. BNA Act of 1867. First of all, we will see what are the provision in Canadian Constitution relating to that federal character of Indian Constitution as provided under the Constitution of India. The that BNA Act, it is an abbreviation. As I have said that your habits to write the short. If you will read the H.M. Sirvai, as I have said, the various times he was very learned jurist. He was advocate in Supreme Court, Attorney General, and written the research paper, did the work on the Constitution, correlated the matters with other provisions of other countries and the Government of India Act, analyzed it and propounded the theory in the area of Constitution. Therefore, if you will read the book written by that H.M. Sirvai, he has also used the word abbreviation in his text. And basically, once he is writing the full name, then he is habited to write the abbreviation in every line or most of the lines, most of the paragraphs, most of the chapters. He has done it. And he was a very the ideal jurist. Still, he is a ideal jurist because his philosophy is there for the development of the law in India. So that's why BNA Act 1867 in Canada. What is the full name of this BNA Act? Its name is British North American Act. British North American Act 1867. And in that act was enacted by the Britishers. That act was 1867 act was enacted by the Britishers for the North America, which is called today the Canada. It is a Canada. So therefore, the foot model relating to this federalism, in respect of the federalism, with reference to of the federalism, is existing in the Canada. This is our legal duty to discuss it and then apply it. Therefore, I am saying, I am just expressing the views. Please don't take the study of cheap books. As I have seen in bibliography, some students are written this Pasandi Babel or these things. Please avoid all these things. I am going to be fed up by reading all these cheap sources. And the source of your material should be a very authentic source. Authentic source. So I know you are in, under the lockup because of this epidemic disease. I am very much aware. But everyone have the internet, access the internet, and there are various sites. And then go with the good side. I am also doing my study because I am in Lucknow. I have library, but I have shifted some books to the Almora. But some good books are here. Even if I'm studying from the internet for your the betterment of the information, that is essential. Again, it requires to verify by searching the one and another. Please, that's why I do that one. And I know some students have some problem relating to the language, but mostly I have said that good literature for purpose of LLM, there is no in the Hindi books written by some. The books are not sufficient. Reports, commentaries, and the details in internet. But that is the point. So therefore, the British Parliament had enacted that law, which is called the BNA Act of 1867. And then before entering into that part, what are the provision for the distribution of power in between the province and the state? We have to require to discuss some issues with this BNA Act as well as the American Constitution, as I have pointed out, the Article 1 and the Section 8 of that Constitution. Yesterday I have highlighted, and the another is Article 1, Section 10 of the American Constitution. But at the same time, the Australian Constitution is also there, and that is enacted by also this power, under the power of Britishers, and it is the 1900 that is existing in that state. Therefore, the point before the discussing all these things, what are the issues which can be correlated with the Indian system? Now, these are the points, as I have also given the idea yesterday, but I'm just again quoting these points. What are the points, under which points, which is called the caption, which is called the heading of the discussing the federalism system in India with correlative aspect with the Canadian system, Australian system, USA system, and the GOI, Government of India Act also. And these are the four the most relevant pillars where we will search the points and then we will apply it. And whenever there will be any issue, we will go on the source and the situation, facts of the case, and then other standing aspect, and then certainly one will reach in the conclusion to say that yes, the solution of this problem is can be traced out in the way, or in this way means in the way of the comparative study or comparison in between the various aspects. These points are the first point, as I have said, and always it should be in your mind that the first point is the distribution of legislative power. This is the first point. Ranjit is disturbing me. Please don't disturb me, because he opening the mic always, again and again he is coming. It may be the internet problem, but at the same time I am also facing this one, because in India such type of things are not here. Full facility is not being provided because of the instrument and that is given by some company everyone is facing, and 2 and 3 connections I have taken, Wi-Fi, all these things, but that is another aspect. Then point number 1 is distribution of legislative power, first of all. And before that, it requires to know the territorial aspect also. Territorial aspect of the particular country as provided under the constitutional system of that country. And if you will see the Article 1, you may be aware, you may remember that Article 1. Article 1 start from the Article 1 and goes up to the 395. 22 part, and this 12 schedule. Earlier at the time of making, there were less schedules rather than the schedule were under the GOI. My point is territorial aspect. Then second is distribution of legislative power. Distribution, because the federalism, we have reached in conclusion that the meaning of the federalism is distributive power, distribution of power in between the units, and at the another side there is center, union, federal, whatever name according to the constitution. Then try to understand why I am using these words, and it should be kept by all the persons in their own mind. The third one is the distribution of executive power. The whole meaning of the federalism is distributive power, distribution of powers. And distribution of powers can be seen that after the 5 and 10 minutes, I will start the second one, please. And the indication it has been given, because getting the so many problems in internet, but continuously I will take your class. Then distribution of executive power and the administrative power. Distribution of administrative power, and there are the provision in the Indian Constitution also. There are the provision in the Canadian, that BNA Act 1867. There are some provisions in the Australian Constitution of 1900, and there is the provision of American Constitution of that 1787, and the same provisions are existing under that GOI Act of 1935. Therefore, the provisions are there for the distribution of powers. That is legislative, that is executive, that is administrative. And here in India, if you will see, it starts from the Article 245, and the legislative power we will discuss, because it is not possible to discuss all the things, but the idea can be given. And please you search, then read each and every portion of article, and the law laid down by the court, and the analysis of the court. You should have the habit to continuously, whenever you are, and your habit should be to read it. Administrative, and then legislative, executive power, and one more aspect is war and emergency also. In every country at the time of the war, the impel power, absolute power, complete power given by the constitution to the union, to federal, to center, whatever name will be there. Don't be confused. If the student have even if the Hindi medium, these are the common words. These are the common words that what I am using here. The name as is given to the center government according to their constitutional system. Then Territorial status, I will discuss this one with reference to India in the first aspect, and the matters allocated to the union and the states, matters, other matters. There is one of the very relevant aspect, residuary power. Residuary power in Canada also, under this BNA Act, it is vested on the federal government and federal the legislature, judiciary power. In the same way, in India also, there is one article, that is Article 248. Article 248, which says about the residuary power of the parliament. Even if there is no subject enumerated or written or prescribed under any list, that is the state list or concurrent list, the parliament have the power. Parliament have the power to make the law, and therefore this is also called matters allocated to union and states. Then depends of union on state. Yesterday I have said that there are some provisions. These provisions are election of the Council of States in India, and this is most relevant aspect about the state depends, sorry, the union depends on the state also, and sometimes the majority of the another party will be there in the Council of State, Rajya Sabha, the Council of States, Rajya Sabha, there will be the majority. And the other aspect of the, that is the two, in nutshell or in the sum up, what can be said about the federal system in the India. Of course, this federal issue has discussed by the court from 1978. Before that also, there is another case of 1964, and your duty to search these cases, although the West Bengal versus Union of India 64, when there was the issue of the coal mining and all these things, which is existing within the territory of a state of that West Bengal, or maybe in any other states, and what will be the power to regulate that resources in that system. There was the aspect, and decided the court that in 64, we will discuss later on, but the court has decided no, there is no federal in 1964. I am talking about the 1964. But when there was, even if you will go through the HM survey, please, it is my suggestion that latest edition of HM survey, Subhas Kashyap, LM Singhvi, the volumes and commentary should be in your library, in your personal library, and the Constituent Assembly debate should be there, and the Act 1935, of course, that is available in the website. Debate is available, but there should be hard copy in your library. Either you may be the practitioner in the subordinate court and in the high court or in some other places, but that should be in your library. And for that purpose, they purchase all these books and go through it and deeply study it whenever you are getting the time. If you are practitioner advocate in high court, whenever a issue comes, for the detailed discussion, for developing your argument and speaking before the court in a way so that court may also think that you have the special kind of capacity rather than the capacity of other advocates. That should be your study. Now come to this first portion, which I have said that the territorial aspect. And for the purpose of the territorial aspect, in every constitution, there will be the territorial system, and that territorial system says about the territory of a particular country. Now, I have said that there is one article, the first article of Indian Constitution in India, what it says, and how it has the system about the territory of states and the territory of India. You know that every student should know that name of India is given by the Constitution of India itself. It is a document who has prescribed the name of India. That is the subject matter of Article 1. And it says that there are 3 clauses, as I have said, and for territorial purpose, we will see some other aspect, Article 2 to 4. But detailed discussion is not possible in online lecture. This is sufficient if I am giving you the indication. In such form, the one cannot get the material in the website, or some website have some wrong information. I have seen also yesterday night when I was studying that I have seen they have said that under schedule 7th, under the list 1 union list, which is called the some website had written there are the item 100 item they have written, whereas 97 items only there. And they have in the same way said about this list second, state list and the concurrent list also. They have increased or decreased the item, but I can't say where they have got this information. And it requires to verify by other side also. There are various sites, and the government side is the authentic side, because in today's technology there is no facility except the facility, easy access of the internet. Therefore one can believe on it, and it requires to cite it. But at this before citing, it shall be our duty, including the duty of the person who is studying up to the time of the death also. It is the duty to verify it from other sources. If one will reach in the conclusion that this is the truthness of the information, and that should be, then Article 1 which says that India, that is Bharat, always it should